The next matter to come before the court this morning is Bank of New York Mellon versus Adam Verlie. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, if you let me know when you get started, I'll keep the clock and keep you apprised of the passage of time. We've read the briefs and we are ready to proceed when you are.
Good morning. My name is Grace Doberdruck. I'm representing appellants Adam and Donna Verlie. In City Mortgage versus Ranowski, the Ohio Supreme Court reasoned that a homeowner could appeal from a confirmation of sale. And appeals from confirmation of sale are usually reviewed under abuse of discretion standard. In this particular case, the homeowners had filed a motion to vacate, and objections to the motion to vacate were still pending, but the sale was confirmed. And so the homeowners would say that that was an abuse of discretion because there's still a legal challenge out there of whether there was a valid judgment, that the court should have postponed confirming the sale until there was an official ruling on these objections to the magistrate's decision.
This order confirming sale and distributing proceeds, was that stayed?
I don't believe it was.
So this is now moved or no?
Potentially, yes.
Potentially. So it's the argument that because of the outstanding objections that what happened was some sort of a nullity, or I'm trying to understand why this isn't moved.
There's that, Your Honor. There's also the Wells Fargo versus Washington case that we cited, where a confirmation of sale was reversed and the actual judgment was reversed based on a jurisdictional issue. And in this case, the 9th District Court of Appeals still holds that you need to have the note and the mortgage when you get a judgment of foreclosure, or you're not entitled to one. That's BAC versus McFerrin. And that's still the current law in the 9th District. And in this case, there's an issue of whether the appellee had possession of the original note when the judgment was rendered. And in the motion to vacate hearing, no original note was produced. So we had an affidavit filed by one person, and then the person who showed up at the motion to vacate hearing, Nathan Music from Bank of America, he had actually stated, which is cited within the brief, that he was 80% sure that the promissory note was in Bank of America's vault. And so there's a factual issue of whether they actually had possession of the original note. There's also a unique situation here, is that there's a loan modification that was payable to Countrywide Home Loan Servicing, and the plaintiff in this case was the Bank of New York Mellon, formerly known as the Bank of New York, as trustee for the benefit of the certificate holders of the CWEBs Inc. Asset-Backed Certificate Series 2006 BC1 Trust. And there's really no evidence presented that this modification was enforceable by that particular named plaintiff. And if they didn't have the actual original note, which the note attached to the complaint was not endorsed, there might have been some indication that at some point later it was endorsed. And there was an issue also with Nathan Music's knowledge about reading these records and if he understood what was actually being stated in these screenshots. But the note attached to the complaint is not endorsed, and the note was originally payable to Mila Inc. So we've got a note attached to the complaint that's not endorsed. Remember, this is a default judgment case. And then we've got a loan modification that has the lender as Countrywide Home Loan Servicing LP. And because it's a default judgment case, this is distinguishable from CUPTA, because in CUPTA there was a pro se answer filed, and then a summary judgment motion was filed, and the CUPTA's failure to respond to the summary judgment motion barred them from litigating these issues because they had raised the issue that the person who sued them was not the same person that they took the note with. And so the court had held that because they had made that, they had checked this box in a form, that issue was raised and they were barred. Unlike the Verlies, there was no answer filed, so they didn't put that actual issue before the court. And the other issue with CUPTA was a 60B3 motion where the Ninth District Court had held that because the CUPTAs had alleged that the plaintiff said they were the holder of the note and they really weren't, that was akin to fraud. Also because the mortgage hadn't been assigned to them yet, that they were able to challenge that through 60B3. The Supreme Court of Ohio in CUPTA had said that standing is a meritorious defense, but the 60B3 prong, was the problem because you couldn't say it was fraud on an issue of standing that could have been appealed from when the CUPTAs had actually written something about that in their answer.
So we have an appeal from the order confirming sale and an objection to findings that were made in the order of decree of foreclosure. Is that correct?
Yes, there's a motion to vacate in the hearing, and the objections are on the hearing.
Okay. The hearing was on the motion to vacate
the judgment
order of foreclosure?
Yes.
Okay. And the hearing took testimony regarding the status of the bearer of the note?
Yes, I think eventually there's an allonge. And so there's also an issue of whether this allonge was affixed to the note when the complaint was filed. As I said, the complaint doesn't include an allonge and it doesn't have an endorsement. And then the other issue at the testimony at this motion to vacate hearing is that the witness, who was an employee of Bank of America, said that he was 80% sure that the note was in Bank of America's vault.
Well, okay. Can we go back to Judge Hensel's question? Was the appeal is from the order confirming sale?
Yes, under the basis that it's erroneous to confirm the sale when there's an issue of whether this judgment was actually valid.
Well, so that sort of is like saying we've attached the order confirming sale to our notice of appeal, but what we really want to talk about is the foreclosure order. And the case law just doesn't permit you to do that. There's nothing in your brief that talks about any respects in which the sale confirmation was deficient.
And Your Honor, I think that kind of comes from in City Mortgage versus Radnowski, the Supreme Court, from reading the decision, it looks like they had contemplated that there was going to be a hearing on, prior to confirmation, that there would be a hearing on these other amounts and charges. And the trial courts, the common pleas courts, have just not been doing that. So there is really no basis to challenge any amounts because they just get the bank's attorney files confirmation and it just gets stamped. And there's no way to appeal from these amounts because when the confirmation gets submitted, which sometimes it doesn't even get sent to attorney for the homeowner or to the homeowner, it's just something that's filed with the court by the bank's counsel. And then a confirmation stamp, and if you try to appeal and say, oh, I'm going to challenge this amount, then the argument would be that there's no evidence in the record about a previous challenge. That the homeowner didn't make any argument challenging any specific amount. But they're never really given an opportunity because sometimes you don't even know that the confirmation is pending. You know that there's a sale, but the homeowner or homeowner's counsel might not be aware of when this confirmation is submitted. And then the order comes out, and there is no hearing held. And the Supreme Court of Ohio in City Mortgage versus Radnowski had held that the judgment of foreclosure could still be final by not having these amounts because these amounts would be addressed at confirmation. But they're really, in the actual practice of foreclosures not being addressed, It's more of a process of the bank submitting what they want in the confirmation and it getting granted. And so in this...
So is that a matter for this court to consider, or is that a matter for the legislature to sort out? I guess I'm not...
What we're saying is, if you look at, if this court agrees that City Mortgage versus Rosnowski requires more than just a ministerial or administrative stamping of a confirmation entry, that it actually does require a hearing, then this court should reverse the confirmation of sale because the hearing did not occur in this case. And because these objections were still pending, which could have been a basis also not to confirm the sale because the actual judgment of foreclosure might not have been proper.
And you have just under 5 minutes if you wish to reserve any time for
Thank you.
Good morning, Your Honors, and may it please the Court. My name is Matt Richardson, and I represent Bank of New York Mellon in this appeal. I also will be brief. This Court should affirm the trial court for 2 reasons. First, the borrowers improperly appealed the trial court's sale confirmation entry as a ruse for challenging the foreclosure judgment. Second, even if the borrowers were not barred from challenging the judgment because they improperly appealed the sale confirmation entry, the High Supreme Court's Kuchka opinion denies them relief for their motion to vacate judgment. Any motion to vacate, whether it's under a common law standard or 60B, is reviewed under an abuse of discretion standard. That means that the trial court cannot err unless it engages in arbitrary, unconscionable, or unreasonable decision-making.
Well, we don't have a ruling on the motion to vacate, do we? And yet?
That's correct. That's correct. And what I don't understand is why the borrowers didn't move for limited remand so that the trial court could actually decide that issue and make that a final appeal order. That is certainly an option, and they did not take it. Just 4 days after my client filed its appellate brief in this case, this court issued its opinion in St. Pinio. And I find it odd that opposing counsel is raising Rosnowski as a basis for vacating when this court relied on Rosnowski to hold that a borrower only has a limited right to appeal a sale confirmation entry and cannot use an appeal of a confirmation entry to challenge a foreclosure judgment. This court followed the High Supreme Court in its Rosnowski decision to conclude that, quote, the confirmation process in a foreclosure action is an ancillary one in which the issues present are limited to whether the sale proceedings conform to law. Once the order of foreclosure is final and the appeals process has been completed, all rights and responsibilities of the parties have been determined and can no longer be challenged. And that is exactly what the borrowers are trying to do impermissibly. Even before Rosnowski, this court had reached the same conclusions in its Rohde decision from 2006. Under Rohde, the appellant in an appeal of a sale confirmation entry, quote, is limited to challenging the sheriff's sale, the confirmation order, or other events that occurred after the decree of foreclosure. After. Instead, issues regarding the validity of the foreclosure are not before the court. That's exactly the situation we have here. No issues regarding Mellon's standing or the validity of the foreclosure are properly before this court. The only issues properly before this court would be issues relating to the sale process, but the borrowers have not raised any, although today is the first time that I've heard any issues at all in this appeal that the borrowers have raised with respect to the sale process. For this reason, this court should affirm. Additionally, the motion is barred by res judicata under Kuchka. Even if the borrowers could challenge the judgment through an appeal of the sale confirmation entry, Kuchka denies any relief. Under Kuchka, the borrowers are barred from collaterally challenging a foreclosure judgment where the borrowers could have raised the issues they raised in the motion to vacate before the trial court or on appeal. Instead, in the trial court, the borrowers did not respond to the complaint, did not challenge Mellon's standing until 2 weeks after the property sold, after the judgment and ensuing appeal period had expired. And to answer Your Honor's question to Judge Hensel about whether there was a stay, there was a stay, and the borrowers were granted an evidentiary hearing after the sale had occurred, before confirmation.
Okay, let's go ahead.
What's the status? Is this moot? Have the funds been distributed?
Yes, in fact, the sheriff deed is issued 9 months ago.
You know, it's helpful when that happens for the parties or one of the parties to file something with the court because we can resolve the case on that basis.
I appreciate that, Your Honor. Thank you. And this court, and it was Your Honor's opinion, Judge Moore, in Vasquez in March of this year as well, decided a case in which the borrowers filed a common law motion to vacate judgment on grounds that there was no jurisdiction lacking, specifically on grounds that the plaintiff lacked standing. And this court stated that under Kuchka, that type of challenge is impermissible. And that a 60B3, or I'm sorry, not a 60B3, but a 60B motion would be necessary to see the judgment vacated, but with raising issues that could not have been raised before judgment or appeal. For these reasons, res judicata bars the borrower from succeeding on their common law motion to vacate. A common law motion to vacate is not a substitute for a timely appeal. I also say that, too, that opposing counsel mentioned that there was a default judgment scenario here, unlike in Kuchka. Well, in this court in Vasquez, that was a default judgment situation as well. And this court did not distinguish between default judgment and a summary judgment in this context. As a result, this court should affirm the trial court in every respect. And if there are no questions, I'll sit down.
The issue before the court, in some regards, is similar to Wells Fargo Bank versus Washington, where the court looked to whether the sale conformed to the law. And to make that determination, you first had to have a valid judgment of foreclosure. And as I said, in Wells Fargo Bank versus Washington, the court found because there's this jurisdictional defect and there is no valid judgment of foreclosure, then there could not be a valid judgment of sale or confirmation of sale, and reversed all of those judgments. And we'd make the argument here, because of this Court of Appeals holding in VAC Home Loan Servicing versus McLaren, and requirement that the appellee actually have the note and mortgage, and due to this motion to vacate, testimony that appears they didn't maybe have the note or weren't sure that they had the original note, that there wouldn't be standing, the appellee wouldn't have jurisdiction to have this judgment.
How does this court, with respect to this appeal, even reach any of the Kuchka arguments, considering the fact, again, that there is no finding on the trial court level regarding those arguments on the motion to vacate? What court allows us to do that?
What allows us to do that is that we can look at the note that's attached to the complaint and see that it's unendorsed. It's payable to Mila Inc.
But okay, I understand what you're saying in terms of the merits of that argument. But we don't have any ruling from the trial court on the merits of that argument.
That's true, Your Honor, but we do have testimony at this hearing, which we've cited some testimony about the uncertainty that the witness for Bank of America had. And so that is sworn testimony that's before the court that was raised in this issue. And what makes this case unique is that we're challenging the actual validity of the judgment, which, if this court were to find that these judgments were voidable, then under the statute, potentially there's an issue.
But we'd be finding that in the first instance rather than on appellate review, because the trial court didn't rule on that.
And what this court would have to do, and what we'd be asking you to do, is to simply say that it was an abuse of discretion or erroneous to confirm the sale when there was this type of testimony before the trial court, and when there was still a challenging question about the validity of the judgment, and also no hearing process on the confirmation. That these situations would make it a reason to reverse the judgment and then let the trial court actually make a decision on the motion to vacate. And so appellants Adam and Donna Verlie would respectfully request that you reverse the decision.
Thank you both for your presentations today. The court will take the matter under advisement. A decision will be issued mailed to both sides as well as posted on the Ohio Supreme Court website. We are adjourned until Thursday at 7 p.m.